Hello, everyone. Welcome to Assembly Public Safety and Security Special Committee. Welcome this afternoon. We're starting just a little bit later than we thought, but we're on special session time. So, Ms. Dory, with that, will you go ahead and please take a roll?
Assembly members Cole, here. Considine, here. Dahlia, here. Gonzalez, here. Gurr, here. Hanson, here. Hardy, here. Karras, here. Marzola, present. Moore, here. Orentlicker, here. Patchett, here. Roth, here. Chair Miller.
Here, thank you. And please mark any members present when they arrive. With that, just a few housekeeping items. Again, I ask that everyone please turn their electronic items off so that it's not disruptive during the hearings. Also, you may see members on their laptops and phones and things like that. Please don't take that as anything but research and not as a sign of, inattention. We will have just so you know, the agenda, we will be taking things out of order. So the first bill we will hear today is Senate Bill 2, then Senate Bill 1, Senate Bill 7, and then we will have a work session. For presenters, we ask that you keep your presentations to 15 minutes each. After that, we will have testimony, and we ask that each speaker states their name, spells their name, and of course keeps their comments to 2 minutes each. And then we will have public comment at the end. With that, I understand that everyone knows that they're also able to view this and follow along on Nellis or our YouTube station. So with that, we will go ahead and open up our first hearing, which is Senate Bill 2, which revises provisions relating to legislative affairs. So your hearing is open. I ask that you introduce yourself, spell your name, and proceed when you are ready.
Thank you, Madam Chair, members of the committee, Asher Killian, Legislative Counsel, ASHER, KILLIAN. Given the lateness of the hour and the specialness of the session, I will keep my remarks on this bill brief. This bill is very similar to Assembly Bill 600, which passed during the regular session. There are three things that this bill does. The first is, you may have noticed that we have delis now on both the northern and southern campuses of the legislature. We had some questions from the state controller about whether the law was clear enough that we could keep the revenue from the proceeds of those delis within the legislative fund. Sections 1 and 2 of the bill make it clear that the revenue from those delis would remain within the legislative fund. Section 4 of the bill, moving out of order, you may recall that near the end of the regular session, the legislature authorized the purchase of a parking lot that is contiguous to the legislative property here in the north. That purchase was actually completed. Section 4 of the bill adds that property to the list of properties in NRS 331-135 that are under the exclusive control of the legislature. So that's a housekeeping piece to reflect that purchase of property that was authorized by the legislature. The final item in Section 3 relates to the codification of the Nevada Revised Statutes. I promise not to pull a full Kevin Powers and go back to the Magna Carta of 1215 on you, but just for a little bit of history, the Nevada Revised Statutes came into existence in 1957 by an act of the legislature. That was the conclusion of a 6-year process that began in 1951 with the creation of the Statute Revision Commission to create the Nevada Revised Statutes. The charge from the Statute Revision Commission, for the Statute Revision Commission from the legislature, was to organize all of Nevada's laws in the following order, beginning first with laws of a remedial nature, so remedies that are available in court, moving second to laws of a civil nature, so laws that govern civil procedure in court, third, laws of a criminal nature, so laws dealing with crimes and punishments, and then finally, laws of a political nature, which is literally everything that doesn't relate to either remedies, civil law, or criminal law. For the laws of a political nature, which are the bulk of NRS, the direction to the Legislative Council in Chapter 220 of NRS is to organize those by subject. There was a recent Supreme Court decision where the court, I think, erroneously assumed that the provisions of NRS are organized by branch of government as opposed to by topic. Under the law in Chapter 220, they're required to be organized by topic. If this language were not adopted, we're currently in the process of codifying NRS following the 2025 regular session. If this language were not adopted, that opinion from the Supreme Court would require us to recodify all of NRS into 4 titles rather than the 59 that exist, which would be a large undertaking that would burn hundreds of hours and likely millions of dollars of staff time. I also think nobody wants NRS to be in 4 giant titles instead of 59 titles. So passing this bill would allow us to not do that during the codification process that's currently underway and leave NRS organized the way that it currently is. Madam Chair, that concludes my presentation. I'm happy to answer any questions that the committee may have.
Thank you so much. Members, any questions? At this point, I do not see any questions, so I will go ahead and open it up for testimony. We'll start with testimony in support. If there's anyone that would like to come forward here in Carson City and testify in support of Senate Bill 2. Not seeing anyone here or in Las Vegas, I will open it up for opposition testimony. Not seeing anyone here or in Las Vegas, I will open it up for neutral testimony. Also not seeing anyone here or in Las Vegas. Mr. Killian, do you have any closing remarks? So with that, I will go ahead and I think our shortest hearing ever was 3 minutes, so you're just on the line. But with that, I will go ahead and close the hearing for Senate Bill 2. Thank you so much. Next, I will open the hearing for Senate Bill 1. Senate Bill 1 revises provisions governing the short-term lease of a passenger car. So the same, I will give you all a few moments to get settled. When you are, please introduce yourself, spell your name for the record, and then proceed. And again, your presentation I know will be less than perfect.
Maybe not 3 minutes, Madam Chair, but short.
That's okay.
Madam Chair, members of the esteemed committee, Warren Hardy representing Enterprise Mobility. We're here for a technical change to what we believe better represents what we tried to do last session in SB 194. So I'll try to anticipate a couple of questions. Why did we not get this right in the regular session? And what in this rises this to the level of a special session request? So in SB 194 of the last session, I represent Enterprise Mobility. They are a large multinational corporation. But we do have partners who are family-owned franchisees who are represented by my esteemed colleague and friend, Charlie De La Paz, who joins me at the table. They came to us last session and said, the law as it currently exists, this is prior to the passage of SB 194, prohibits a rental car agency from denying a rental to an individual who doesn't have insurance and who is unwilling to purchase a supplemental insurance. They were not permitted to deny a rental. They had to rent a car. That is not an issue that my client was concerned about. Ms. De La Paz's client did have some concerns with that, some liability concerns with that, but we supported them in moving forward. My only request at the time was, please don't do anything that changes the way we do business. Enterprise Mobility would like to do business as usual. We rent you a car regardless of whether you have insurance, because all of our cars are insured. We're a major corporation. We have the appropriate insurance on all of the vehicles. So we moved forward with this legislation. I asked towards the end, this doesn't change in any way the way I do business. No, it does not. That was the answer. So the provision that I just referenced in statute that was the law before says, except as otherwise provided in subsection 2, a short-term lessor shall not require the purchase of a waiver or damages, et cetera, et cetera, et cetera. So it kept the existing law, except it adds subsection 2. Subsection 2 provides a list of, or provides an opportunity for the rental car company to optionally deny rental if they felt there was liability associated with the renter. And their reasoning made sense to me. Although we haven't really experienced or not aware that we experienced it, the concern that they were trying to address was that you have an individual who is, for whatever reason, uninsurable. So Warren Hardy has 3 DUIs. I get my license back, but I can't get insurance. Insurance underwriters won't underwrite me, or I have an SR22 that's very, very expensive. So I decide instead of owning my own car, I rent a car, which effectively passes the liability on to a company who has no ability to do an actuarial, and because of the previous law, has no ability to deny insurance. Again, not something my client concerns itself with, but I certainly understand why our franchisee partners did. So that was what this was intended to fix. So how I missed it last session is I was under the impression that subsection 2 was a optional alternative process that we could follow if we wanted to, or we didn't have to do it if we didn't want to. And since my client intended to continue on the status quo and rent cars regardless, we didn't think much about it. Well, it got to our actuarial folks who read it when it says short-term lessor shall require that a person seeking to lease a passenger car provide proof of insurance that satisfies the minimum account requirements of insurance in the state of Nevada. We have no way to do that. We have no way to verify somebody from Japan, somebody from New York, somebody from Utah who has different minimum standards. They could provide us the insurance card, but we don't know that it's valid, and our guys aren't trained to know what the minimum requirements in those states are, which is why we wanted it optional. So for the first time in this statute, and the concern that brings it to the level of a special session fix, is that my client felt there was a possibility for significant liability if we have a statutory obligation to perform a duty, which in this case is verify that they have insurance that meets the minimum standards, and we are unable to do that. So what this change does, going from shall to may, simply takes us back to what we all understood the original legislative intent was, to say that if you want to avail yourself as a rental car company of the subsection 2, you can. If you don't want to, you don't have to. My client wants to continue with the status quo. Ms. De La Paz may want to do something different. This accomplishes that. We missed the may and the shall, and the may gives us the flexibility. That was as brief as I could be, Madam Chair. Very happy to answer any questions.
Thank you so much. Members, are there any questions? Not seeing any, I will open it up for testimony, beginning here in Carson City. Anyone wishing to testify in support of Senate Bill 1? You will have 2 minutes for your testimony. Please, again, state your name and spell it so we have it correct for the record.
Thank you, Madam Chair. Victoria Supple, S-U-P-P-L-E, representing the Nevada Franchise Auto Dealers Association. We support Senate Bill 1 because it provides reasonable flexibility for short-term lessors by allowing, rather than requiring, them to collect proof of insurance. This small change helps streamline the process for loaner and rental vehicles while maintaining all existing insurance protections. We appreciate the bill sponsor and ask for your support. Thank you.
Thank you so much. Not seeing anyone else here in Carson City approach. Is there anyone in Las Vegas that would like to testify? Not seeing anyone, I will open it up for opposition testimony, beginning here in Carson City. Not seeing anyone approach in Las Vegas, I will open it up for neutral testimony. Also not seeing anyone come forward here in Las Vegas, here in Carson City, or in Las Vegas, I will go ahead and close testimony and ask if the bill presenters would like to make any. Okay, so there will be no final remarks on Senate Bill 1, so I will go ahead and close the hearing on Senate Bill 1. Next, we have Senate Bill 7. So Senate Bill 7 revises provisions relating to heart and lung. And with that, I will welcome the presenters up for Senate Bill 7. Once you're settled, please go ahead and introduce yourselves, state your name, spell your name for the record, and then proceed when you're ready.
Thank you, Madam Chair. For the record, Ryan Beeman, last name is Beeman, B-E-A-M-A-N, first name is Ryan, R-Y-A-N. Thank you, Madam Chair and the committee for hearing this important piece of legislation, SB 7. As I said, for the record, my name is Ryan Beeman, representing the professional firefighters in Nevada. I'm here today to testify in support of this bill to clarify and restore I was like, already? I was like, that was quick. And to restore the conclusive presumptive for lung disease, NRS 617455. Just a quick background on this piece of legislation. In 1965, the legislature enacted the lung disease statute with causation-based standard. Proof that lung disease resulted from exposure to heat, smoke, fumes, tear gas, or other noxious gas. That structure remained today as the bill's written in subsection 1. In 1989, through AB 755, the legislature made a deliberate policy shift, recognizing the difficulty of proving causation for both heart and lung claims. Lawmakers adopted a conclusive presumption for professional firefighters, arson investigators, and police officers after 2 years of continuous uninterrupted salary service. This created two distinct mechanisms: exposure-based claims under subsection 1, which remain available for volunteers, and another provision, conclusive presumptive claims under subsection 5, based solely on the years of qualified service for professional firefighters, police officers, and arson investigators. The Nevada Supreme Court confirmed this reading for heart disease in the Manuel versus Clark County in 2007, holding that the conclusive presumption operations independently of causation and applies even to congenital or pre-existing heart conditions. This is exactly how the 1989 legislature intended the presumption to function. The problem is the past two appellant decisions, Las Vegas Metro versus Watterson, and then also another recent one that just happened in the last couple of days from the Supreme Court, which was Hooligan versus the Henderson, have upended this settled understanding. Both courts held that the lung conclusive presumption in subsection 5 is not independent and the claims must still prove exposure under subsection 1. The interpretation collapses the conclusive presumption into a non-existence, reverses decades of consistent practice, and undermines the legislature's clear intent in 1989. The result is immediate disruption. Lung disease claims for professional firefighters, police officers, and arson investigators will now be denied unless they can prove a specific exposure and an impossible burden in many cases. This doesn't only affect active employees. Our current retirees who served decades under the belief that their lung claims were protected just as their hearts were now faced with uncertainty. Many of them are already battling chronic lung conditions for years of service. They are now their families relied on the conclusive presumption for security in their retirement. These were promises Nevada made in 1989 after 2 years of continuous service would be conclusively presumed job-related. The bill now, what we're trying to do with understanding of the bill, makes the narrowest statutory change necessary to restore the legislative intent. It aligns the lung conclusive presumption language, NRS 617455, Section 5, with the heart conclusion presumption language, NRS 617457, Section 1A through C. It ensures that lung presumption functions exactly the same way as heart presumption does under the Manuel case, preserves volunteer firefighters' protection under subsection 1, maintaining their ability to bring exposure-based claims, and clarifies that retroactively applying to all open and pending active and reopened claims because Nevada's first responder communities have long relied on this conclusive presumption. And when I say retroactively, I'm just talking about, like I said, this decision happened 3 days ago. We actually have, I know over a couple hundred claims that are in the process, meaning they're either going through discovery or they're at the first step of a hearings level or appeals level or district court. We wanted to make sure that these individuals don't fall into it like a donut hole. If you do pass this legislation, that local governments can't come back and say, well, that group is exempt because it's now going forward. We don't want them to be in that donut hole when we fix this. And that's what the retroactivity means. And it's not a new cost to the local employer. This is an existing cost that's been there since, as I said, 1989 for 35 years. Just to quickly walk through the bill of the change, subsection 1 remains unchanged. Exposure-based claims are still available. Subsection 5 is updated to mirror the Hart statute, providing a standalone conclusive presumption for 2 years of continuous service. So it means that as a firefighter or a police officer, I don't have to show causation. All it is that I have is the 2 years, and as long as I do all my other physicals and thing, then I fall under the conclusive presumption. Just as we've done for the last 35 years. In closing, this is not an expansion of benefits, as I said. It's a restoration of the legislative intent of 1989. The legislature recognized in providing causation for heart and lung claims was impossible and gave our protectors the conclusive presumption. This bill corrects the misinterpretation with the smallest statutory change possible. It preserves the rights for volunteer firefighters, restores fairness for professional firefighters, police officers, and reaffirms Nevada's promise to those who we protect. I urge your support, and I stand for any questions, but I do have 2 other presenters. They'll be quick on their testimony.
Let me just make sure I'm clear. Testimony or part of the presentation?
Sorry, part of the presentation.
Please proceed.
Thank you, Chair Miller. For the record, Danny Thompson, D-A-N-N-Y, Thompson, T-H-O-M-P-S-O-N. I'm here today representing myself. In 1989, I was in my 5th term as the state assemblyman from District 21 in Henderson. I was the chairman of the Government Affairs Committee, which I had been on for 8 years, and I was the vice chairman of the Labor Committee, which I had held for 10 years previously. And in that time, and during that time, the workers' comp was not privatized. Workers' compensation was the state industrial insurance system, which was run by the state of Nevada. All the people who worked there were state employees, and it was a state-run function of state government and a constitutionally mandated function. So in my years on those committees, I had constituents, and I had constituents come to me and say, you know, I filed a case, a claim, a workers' comp claim, and I've been denied. And in fact, in checking, the local governments were denying every single case in those days. And, you know, it was, the problem was so rampant. I mean, if you look at the North Las Vegas fire stations, they're all named after a dead firefighter, almost all of them, who died of cancer or some other disease. And so I had served on the Labor Committee all those years, and I had heard all of this stuff. And so I went to Kim Morgan, who at the time was in the legal division. She wasn't the director yet. She was a lawyer there, a bill drafter. And I said, I want to know what is the strongest standard that we can put into law to say that I really, really, really mean that if you get cancer and you're a firefighter who puts on their turnouts every day, who uses the hose and squirts the foam, which contains PFAS, and we all know what PFAS forever chemicals, and that's all, that case has been settled now. These guys still have PFAS in their turnouts. I really, really want the strongest standard you can put into law. And the strongest standard you can put to law is a conclusive presumption. And she said, if it's conclusively presumed that you have this problem, it's caused by your job. And so when you talk about the intent, that was my bill. I introduced the bill, and I explained it just like I'm explaining to you, that I really, really mean it, and we really, really want these people covered. And we passed that bill. It was signed by the governor. And today, and these guys can tell you, every one of these cases are denied, and they have to go through the process. But with that conclusive presumption, they have a way to win. And so, you know, this is very important, and this truly is an emergency because there are people who are going to get caught up in this thing who truly need coverage because they got their problem on the job. And this is something that I think is appropriate to be done, and I would urge you to pass this bill to right this wrong decision. Thank you.
Good afternoon, Madam Chair, committee members. Todd Inglesby, President of the Professional Firefighters of Nevada. I want to thank you all for taking the time to hear this important legislation. This legislation is important because not having it in place puts our members in harm's way. It not only prevents them from getting back to see the doctor, to getting treatment, to get back to their jobs that they love, and that's taking care of our citizens and your constituents, but it also, at worst case, they can die from this. Heart and lung are two issues, and if you ever had any of those issues, and we run on them every day, time is at the essence. These cases will prolong the treatment that they're able to get and honestly put people in harm's way. And we've had people up here until we started changing these laws and clarifying these things that have lost their lives literally going through the workers' comp process. And I don't think it's fair. And I knew some of them and are friends with them. We're all family. We live with each other 3 quarters of the year. So we all know each other's families. We take care of each other on and off the job. This is very important for us. That's why it's so important that it's coming up during this special session. And I just want to also explain, this is not an expansion. This is about restoring what was in place since 1989, so 36 years ago. And that changed 3 days ago, and that's why we're here in front of you, and we beg for your support. Thank you.
Thank you, and with that, I'll open it up for member questions. I do not believe we have any, though, at the moment. So I will go ahead and open it up for testimony. Starting here in Carson City, again, please state your name and spell it for the record, and you will have 2 minutes each. Just as a reminder, I should also remind everyone that the committee rules are that you're in full support, full opposition, or neutral, and neutral is not taking a position, just presenting information about the bill. So with that, please continue to proceed.
Good afternoon, Chair, members of the committee. My name is Harrison Porter, Harrisonporter. I'm the Vice Chairman of the Las Vegas Police Managers and Supervisors Association. I'm also representing the Public Safety Alliance of Nevada. Police officers encounter a wide range of airborne hazards during tactical operations, crowd control incidents, meth lab responses, and emergency calls. In many cases, it's simply impossible to isolate a single exposure, especially years later after some symptoms develop. Yet occupational risks are undeniable. Our first responders have never conditioned their willingness to act on whether the air they breathe is safe. They step into unknown and dangerous environments every day to protect our communities. This bill simply ensures that the state honors its commitment to them when the long-term consequences of that service take a toll. Thank you, and I urge you for your support on this bill.
Good afternoon, Madam Chair, members of the committee and staff. Rick McCann, Nevada Association of Public Safety Officers, and a member of the Nevada Law Enforcement Coalition. Simply put, the court got it wrong, in my humble opinion. It happens. Fortuitously, this emergency that we have right now has a fix. You. We can stop the devastation of this decision that puts our public safety officers into harm's way, including it may kill them. They had this benefit, and that benefit was, I believe, mistakenly taken from them. SB 7 returns that benefit and avoids harm to our first responders, which is why we have all been sitting here listening to this. Oh, by the way, just a few months ago, this body extended the heart-lung benefits to all police officers throughout this state. A monumental decision, and for that I thank you. I happen to be privileged to be able to help present that bill. Don't allow a misinterpreted judicial decision to change what you want and have always wanted to protect our first responders. We support SB 7, and we encourage this committee to do the same. Thank you.
Thank you so much. We will move down to Las Vegas for testimony and support.
Good evening, Madam Chair, members of the committee. Jason Mills, M-I-L-L-S, on behalf of the Nevada Justice Association. I would urge your support of this particular bill, particularly so as the presenters have indicated that this right has been in place since 1989, Madam Chair. And the distinction between the heart and lung statutes are based upon historical changes that happened in those particular statutes dating back to 1965 and then 1989. And there are still separations or differences between one of the subsections on the lungs that requires causation, such as for volunteer firefighters, and those folks that do not have continuous and uninterrupted time on service. So proving exposure still exists for those claims. When the legislature modified the rule in 1989, there was no such akin in the heart statute because it only applied to continuous uninterrupted members back then. And what they did is they removed that causation from the heart because it didn't apply to volunteers, and it did not apply to those that weren't in continuous uninterrupted service. So when they added the section in 1989, as Mr. Thompson indicated, that when he brought the bill, the entire point was to separate those two different categories of people, and then also allow those that meet the classification to have the conclusive presumption. Without this conclusive presumption, I can tell you with absolute certainty, not a few, but hundreds of police officers and firefighters in this state will be harmed. No question, no discussion about that. It will absolutely happen. I'm here. I'm at 2 minutes. I understand if there's any questions, since this is the area that I do practice in and understand. If you or any of the members of the committee have, I'm more than happy to answer any legal questions. Thank you, Madam Chair.
Thank you so much. Is there anyone else in Las Vegas that would like to testify in support? Not seeing anyone, then we will go ahead and open up opposition testimony beginning here in Carson City.
Thank you, Madam Chair, members of the committee. Warren Hardy, representing the Nevada Urban Consortium. It's always difficult to...
Please spell your name for the record.
I'm sorry, Warren, W-A-R-R-E-N, Hardy, H-A-R-D-Y. It's always difficult to oppose a bill like this. And I'm not going to, I now had a chance when I testified 3 hours ago in this Senate, I had about 2 minutes to prepare. I've now read the Supreme Court ruling in case. I'm not an attorney and I haven't become one since 3 hours ago, but I do want to bring up some concerns that the cities have with regard to the expansive nature of this. It is true that the statute does provide a conclusive presumption that if you have a lung injury or lung disease, that you are conclusively presumed to have acquired that on the job site. But the statute also has a second, and it is a conclusive presumption, but that ties it back to the 5 or 6 items that the statute listed. That was the nature of the lawsuit. That was the reason for the lawsuit. The court ruled that the individual did automatically have the conclusive presumption benefit in the first instance that he acquired it on the case was COVID, and he claimed that he got it on the job site. And so that presumption helped him. That conclusive presumption took care of that. But what the court ruled was that he did not show that the injury was caused by the 5 things or 6 things or whatever it is mentioned in the statute. So yes, my friends and colleagues have spoken to the first conclusive presumption, but they've ignored the second. And that I would argue, not being an attorney, that the court applied the current law appropriately. I've been told by my friends that it's really not done that way in practice, and that may be the case, but it does beg the question for me is why was there a lawsuit on it when somebody was trying to make them pass the standard of the second standard? So this will have the effect of removing the second causation.
But your time is up.
Thank you.
If you have any additional comments, please submit them in writing.
Hello, for the record, my name is Vincent Guthrow. Last name is spelled G-U-T-H-R-E-A-U. My first name is Vincent, V-I-N-S-O-N. I serve as the Executive Director of NACO, or the Nevada Association of Counties. We serve all 17 of Nevada's counties. We've had, I mentioned in the prior House that we needed some opportunity to review this legislation. You will hear from a county who's had an opportunity to give some community-specific impacts to this legislation. Some of our concerns that we expressed when this legislation was introduced, I don't know, less than 6 hours ago remain. We still believe this is outside the scope of the special session proclamation, and we do have some issues, all of our counties do, on some of the provisions in here on the retroactability. I'll echo the comments of my colleague from the cities and leave it at that. We are opposed at this time as we continue to assess some of the impacts from this, but thank you for the opportunity to speak.
I guess it's good evening, Chair Miller. Assembly Committee on Public Safety and Security. My name is Chris Reese. It's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. Even though it's well-intentioned, we do oppose SB 7. While we have not had a full amount of time to complete the analysis of how much this would cost, it will have a significant financial impact, which does equate to police officers. The bill does change substantively the heart and lung provisions of workers' compensation, and this is a very nuanced issue. Frankly, it deserves a much more detailed and robust discussion, and at this time we are in opposition. Thank you.
Chair Miller, Joanna Jacob on behalf of Clark County. I echo the comments from the previous speakers that we are still trying to determine the impacts of this legislation, and I wish that we did have some time to try and work on some of these issues. I will tell you that our initial concerns are about the retroactive applicability in the bill. Since I wanted to let you know that we are in the process of determining the impacts. Currently, Clark County experiences impacts based on what we have to hold in reserves for workers' comp, what we have for claims data, and what we expect in presumptive liability. We have audited numbers that we just completed in fiscal year 24, and our costs are $267 million. So it's very serious that we want to be able to look at what the impacts would be because of the time and the expeditious nature of this bill. I did feel important to say we do have concerns about the retroactiveness, and any expansion will impact our liability. We're hoping that that's not true, but wanted to put this on the record. Thank you.
Thank you so much. Is there anyone in Las Vegas that would like to offer opposition testimony? Please proceed.
Thank you, Madam Chair, members of the committee. Dalton Hooks, H-O-O-K-S, here on behalf of the Nevada Self-Insurers Association, in opposition, strong opposition to this. As somebody who is a lawyer, practices in this area, we can certainly talk about this. It's important to understand for the members of the committee that this is a decision that was decided on November 13th, 2025 by the Nevada Supreme Court. That is 2 days ago. It was also similarly decided, as was mentioned by the proponents, by the State Court of Appeals, reaching the same conclusion. And they reached the same conclusion because this is long-standing black letter law. It is not a change. They are not mistaken. The law is very clear. The happenstance that this special session exists to allow the litigants in that matter that lost to use these proceedings instead of the judicial process to seek an en banc hearing from the state of Nevada Supreme Court is, in my opinion, inappropriate. The idea that we're fixing this during a special session is a misnomer. The law below simply requires, as was stated before, and I join all the comments from the folks up north, there is a presumption. However, the underpinnings of this law is that it needs to tie to the work, and therefore it has to arise out of an exposure to heat, smoke, fumes, tear gas, or other noxious gases, the things that our firefighters and first responders are exposed to that they can't get a material safety data sheet to show what they're exposed to. That is the purpose. In the case underlying, the individual was exposed to a sick coworker who had COVID, to which every citizen in the state of Nevada was exposed to during that time frame, irrespective of their position. Our first responders have some of the best health insurance for any citizens in the state. And the question isn't whether they should be treated for COVID. The question is whether that should be treated under the Workers' Compensation Act. This body decided in '89, and since then, it was mentioned that we had a legislative session where we went through this omnibus bill for workers' comp. This wasn't addressed. It came up because of a loss.
Thank you so much. Thank you so much.
We urge you to oppose.
Is there anyone else there in Las Vegas wishing to testify? Not seeing anyone, I will open it up for neutral testimony here in Carson City. Not seeing anyone. Is there anyone that would like to testify in neutral in Las Vegas? Also not seeing anyone, so I will welcome the bill presenters back for any final remarks.
Thank you, Madam Chair. Appreciate you guys hearing this bill again. I just have a couple of quick comments. Just again on the word of retro for the bill. We're talking about current claims that are pending, not claims that we've lost. This is about claims that are pending, meaning that they're at some level of the appeals, or they might be even going through discovery. That's what we're talking about retro. So that's the current thing that's been in there in the statute. That's what we're trying to make sure that those people are protected in a donut hole. There was question, I think, about the constitutionality of this bill. And I've been here a long time, and I think they do a fabulous job. LCB, actually, they're the ones that drafted the bill draft. They would look at, they look at the proclamation and has made that decision that this is germane to the issues here. And it's an emergency, meaning that we do have those members out there that can't wait for 2 years to determine if they're going to have an accepted claim or not, or legislative intent here. Members will die. That will happen. So that's why we're here, and it is an emergency to fix now. So thank you.
Todd Inglesby, President of Professional Fires of Nevada. I echo his sentiments. This will harm our members. This will harm our brothers and sisters that do what they do every day to protect our citizens, your constituents, just like our fellow brothers and sisters on the police side of it. This will harm them 100%. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing for Senate Bill 7. Next on our agenda, we do have a work session. We will be having a work session for Assembly Bill 6, Senate Bill 1, Senate Bill 2, and Senate Bill 7. As I stated yesterday, Speaker had waived the rules for us to be able to work session bills and not be held to that 24-hour rule that we typically have. So with that, I will hand it over to our committee policy analyst to begin with Assembly Bill 6.
Thank you, Chair Miller. For the record, Cesar Magrejo, committee policy analyst. As LCB staff, nonpartisan staff, I can neither support nor oppose any of the measures that come before this committee. Assembly Bill 6 revises provisions governing traffic laws. Sponsored by this committee, it was heard yesterday. There is an amendment that was attached to this work session document that was submitted by Joanna Jacob, Government Affairs Manager from Clark County. And the amendment clarifies the statutory reference, specifies that local governments and Nevada Department of Transportation are responsible only for zones within their jurisdictions, and requires the use of standardized signage to mark the beginning and end of each designated school or school crossing zone. And Chair, that's all the amendments.
Thank you for that. Members, any questions? Not seeing any, I will entertain a motion to amend and do pass. So moved. I have a motion from Vice Chair Marzola and a second from Assemblymember Hansen. Any additional comments or questions? Not seeing any, I'll take a vote. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. Thank you, members. We will now move on to Senate Bill 1.
Thank you, Chair. For the record, Cesar Magrejo, committee policy analyst. Senate Bill 1 is sponsored by the Senate Select Committee on Public Safety and Security. This bill relates to short-term leases of passenger cars, and there's no amendments that were submitted to the committee.
Thank you so much. Members, any questions on Senate Bill 1? Not seeing any, I will take a motion to do pass.
So moved.
I have a motion from Vice Chair Marzola. Do I have a second?
Second.
I have a second from Assemblymember Hansen. Any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Any opposed? And the motion passes unanimously. Thank you for that. Next, we will discuss Senate Bill 2. Oh, I should also assign someone with the floor statement. Assemblymember Hanson, would you like that floor statement for Senate Bill 1? Okay. Thank you. Senate Bill 2, please.
Thank you, Chair. For the record, Cesar Margarejo, Committee Policy Analyst. Senate Bill 2, sponsored by the Senate Select Committee on Public Safety and Security. And this bill revises provisions relating to legislative affairs, and there are no amendments submitted.
Thank you. Members, any questions? Not seeing any. I will entertain a motion to do pass Senate Bill 2. I know it was a very contentious bill, so I will take a motion from Vice Chair Marzola and a second from Assemblymember Gurr. Any additional questions or concerns? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will sign that floor statement to Assemblymember Gurr. Assemblymember Considine, get ready. We're going to do one more. Okay. So, Senate Bill 7.
Thank you, Chair. For the record, Cesar Margarejo, Committee Policy Analyst. Senate Bill 7 is sponsored by Senator Canizaro, and this bill revises provisions relating to occupational diseases, and there is no amendment submitted.
Thank you for that. Members, any questions? Not seeing any. I will entertain a motion to do pass. Motion to do pass. Second. Whoa. Okay, so I have a motion from Assemblymember Considine and a second from Assemblymember Dahlia. Members, any additional questions or concerns? All right, not seeing any. All those in. Chair. Yes, ma'am. Oh, we do have a question or concern. Okay, yes, please.
I'm sorry, I was looking at too many things. I'm not comfortable with the amount of complications I think we need to address in this bill. This is my first time even hearing some of this, and I know the original legislation was very complicated. So, love and appreciate our firefighters, police officers, and the exposures and the things that they do. But at this time, I just don't feel I can support this at this time. So, thank you.
Thank you. I appreciate that. Anyone else? Assemblymember Gurr?
I'm not quite where she's at, Chair, but I will vote it out of committee and reserve my right until I find out more. Thank you.
Thank you so much. Any other comments? Okay, not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Nay. Okay, so we have one nay. That's Assemblymember Hanson. The motion passes. Thank you so much, members, and I will assign that floor statement to Assemblymember Okay. I guess I'll assign it to Assemblymember Considine. Thank you so much. We're going to go into a 1-minute recess at this moment. So don't go far, because that means sort of like 1 minute. For that right now.
Yeah.
Do what you need. Oh, finding the technicality. There you go. All right, I'd like to bring back everyone to order. And so what's happening is, as you know, time right now, there is an additional amendment to Assembly Bill 7 that we've already, Assembly Bill 6, that we've already work sessioned. So in order to include that amendment, we're going to rescind the motion as if it never happened, and then redo it all over again, including the new amendment. So with that, do I need to, or just take a motion to rescind?
Motion, second,
Okay.
and then vote.
So with that, I'll go ahead and take a motion to rescind the activities on Assembly Bill 6.
So moved.
So moved. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assembly Member Gonzalez. Members, any additional questions or concerns? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. With that, I will return back to our committee policy analyst to explain Assembly Bill 6 for our work session.
Thank you, Chair. For the record, Cesar Margarejo, Committee Policy Analyst. So this amendment is in addition to the amendment that was already approved by the committee, and this is a conceptual amendment that will be uploaded to Nellis after today's committee. But the conceptual amendment prohibits the inclusion of certain information concerning pupils within a directory of pupils, prohibits the provision of certain information concerning pupils to third parties. It sets forth the method for a third party to request certain information concerning pupils, and requires the compilation of lists containing certain information included in such requests for information. And Madam Chair, that's the conceptual amendment.
Thank you. Members, any additional questions? Not seeing any, I will take a motion to amend and do pass.
So moved.
I have a motion from Vice Chair Marzola. Is there a second? Second. I have a second from Assembly Member Considine. Any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will sign that floor statement to Vice Chair Marzola.
Thank you, Chair.
You're welcome. With that, that concludes our work session for today. The last item on our agenda is public comment. So again, everyone will have 2 minutes to make public comment. I ask that you state your name and spell it correctly for the record. Is there anyone here in Carson City that would like to make public comment? Not seeing anyone, and not seeing anyone in Las Vegas, I will go ahead and close public comment. Members and the public, pay attention to Nellis for posted agendas for tomorrow. And whatever time it may say, it will actually be call of the chair. So with that, thank you so much, members, for your work today. Thank you to the public for participating. With that, we are done with our business for today, and I will adjourn this meeting. Thank you all.